Hello friends, Mandar here. I'm back with another video. Today we are going to talk about a few different topics. One of them is Child Status Protection Act. There are a lot of people who have asked me questions about CSPA and we are going to address some of the things related to it. I'm also going to talk about some other questions regarding 485, EB1 in particular because I have not been covering EB1 and more focusing on EB2 and EB3 lately because that's where much of the contention is. But I'm going to talk about few questions for EB1. So if you're interested in this topic, please stick around until the end and let's get started. If you are here for the first time, welcome. My name is Mandar and I make immigration related videos for US and Canada. I'm not an immigration lawyer, so anything that I say on this video or on my channel is for information purpose only. For your specific immigration needs, you should hire a competent immigration attorney. And if you are interested in the merchandise, please click on the link below and see if you like something. Now let's get started. Now there is a typical scenario mostly in the visa categories that have a long wait list for green card. Particularly I am talking about EB1, EB2 and EB3 for India and China. There could be a wait for up to a decade for the visa numbers to become available, particularly for EB India category, particularly for employment based category for India. In that situation, the primary applicant may have spouse and children who are below the age of 21 and unmarried. But because of the long processing time for the visa number to become available because of the dates retrogression in the priority dates, sometimes people find themselves in the situation where their kids who were below 21 at the time of filing may run out of, in the sense that they turn 21. This situation where the kids can turn 21 before the visa or the green card has been approved is called the aging out situation for the children. Now this situation is very tricky because once the child ages out, which is if they turn 21 before the visa is up or before the green card is approved, they are no longer eligible to remain on the petition of their parents. Now not only they have to file their own green card petition, they also have to file their own non-immigrant visa to remain in the country. Now this aging out situation is very common in Indian community because their EB category visa or employment based category visa has a long wait period. Now Congress recognized that this is a situation which is very common not only in the EB category but also in some other categories like family preference categories where the visa wait time periods could be in decades, during which time or they may fall into this aging out situation. So they enacted a law called Child Status Protection Act, which is CSPA Act. What this means is under certain situations, and we are going to talk about those in particular, the children will not face aging out. Their age will be locked into a certain time frame when they were eligible for a visa number but the processing was not completed. Now CSPA is not available for everybody. It is only available to certain categories. First is immediate relative of the petitioner, which is family sponsored and their derivatives. Then there are other Violence Against Women Act, which is VAWA petitions. Then there is employment based category as well, as I talked about, diversity immigrant visa applications and refugee and asylum seekers. In this category is the CSPA's application in which the children are at the risk of aging out. Now you have to have a pending I-485 application, which is adjustment of status application, which is based on the following underlying petitions. So what are these underlying petitions? One is I-130, which is petition for a relative. I-360 for widower or special immigrant. I-140, which is a petition for employment based green card. I-589, which is for asylum. I-590, which is for application as a refugee. And I-730, which is a relative of refugee. These are the specific petitions which have to be approved and you have to be on the pending I-485 stage to be eligible for CSPA. Now Congress enacted this law on August 6th of 2002. So any petition that was filed on or pending as of this date is eligible for CSPA. Now I'm going to focus on when the age of a child is locked in so that they don't fall into the aging out category. So Congress recognized that this is a problem. They defined a formula based upon which they determine if the age of a person is eligible for CSPA. Now this CSPA age is the lock-in age that the immigration considers. So for those qualified applications, in that the child's age is locked in for the purpose of that particular petition. So what is this CSPA age? Let's look at it. Now this CSPA age is calculated by subtracting the number of days your petition was pending from the age at the time of your visa availability. Say for instance, your primary applicant has filed for adjustment of status on a certain date when the child was still eligible, which is below 21 years of age and unmarried. Now the visa number becomes available after the child turns 21. Say for instance, the visa number becomes available at 21 years of age plus 2 months. So 21 years and 2 months. If your petition was pending for say 6 months, then the CSPA age will be calculated by subtracting 6 months from 21 years and 2 months, which will become 20 years and 8 months. So now 20 years and 8 months will be your CSPA age for the purpose of this 485 application for the child. Hope that makes sense. So this age remains locked in at the time when your visa number becomes available, and if that age is still under 21, then that child remains eligible to get the green card. So hope that makes sense. So this is just an example. I will leave the link in the description for the CSPA, which has lot of different categories. What you need to remember is, even if there is a risk of your child getting aged out for the purpose of the green card, there is a chance that your child's age could be locked in if there was a very long wait period on I-485. So hope that explains, and you can read about the details on the link that I put in the description. Now in this situation, if the child still ages out and their CSPA age still doesn't help them for getting the green card, then you need to hire a really competent lawyer to see how they can remain in the country on a non-immigrant visa and what are the other options that they can apply for their green card. Now path becomes very difficult in this second scenario. In most of the other scenarios, if the wait time on 485 has been significant enough, then you could be in luck to use this CSPA lock-in age. Now let's talk about EB1. Now EB1 for India and China has been current for a very long time, except for last few years. There was suddenly a retrogression and the dates for India went back to 2015. They stayed around 2015-16 for a very long time, until 2 months back in October, when suddenly there were a lot of visa numbers available for EB category, which were spilled over from the family category from last year. So now one thing that I wanted to point out is there are still quotas available within the EB category. So EB1 has a certain number of visas, EB2 has a certain number of visas, and EB3 has certain number of visas. So it's not a single pool for all EB1, EB2 and EB3. They have their own different quotas. If there are more visa numbers available in EB1 category and not enough applicants, then those remaining EB1 category visa numbers become available to EB2 and so on and so forth, and the remaining visa numbers from EB2 category become available for EB3 category. Even between the employment based preference categories, the visa numbers can spill over, but that rarely happens because more times than not there are enough visa applicants in these categories to use up all the visa numbers in that particular category. But obviously, because of the stringent requirements of EB1A, EB1B and EB1C, there are less number of applicants that use up all the visas, but there is less retrogression, and there are more number of applicants in EB2 and EB3, so that's why the backlog is greater for EB2 and EB3 than in EB1. Now we have seen a lot of progression in EB1 in the last 2 months, and I anticipate that the progression will continue in the next several months until the final action dates for EB1 become current. And lately we have also been seen that the 485 applications or adjustment of status applications that were filed in October and November still haven't received the receipt notices. We are seeing that the receipt notices are coming well after a month or around a month time frame. Now next question was, when do we receive our biometrics appointment? Typically they used to come in within 2 weeks or 3 weeks, but now we are seeing that it's taking about 2 months for the biometric letters to arrive. Check out my video on things to consider after application for I-485 or adjustment of status, where I talk in details about these biometric appointments and so on. Now another question that I got was about travel during pending I-485. Now as I mentioned, you should have your travel authorization card, which is advanced parole combo card, to travel outside the United States. Now this is only if you are using the actual EAD and AP combo card. If you have a valid non-immigrant visa stamped on your passport, which is valid until the time you come back, then you do not need this combo card. Then you can stay out of the United States for a certain duration and come back before that visa expires. Mind you, if the visa expires, then you have a problem, because then you cannot come in unless you have another valid stamp stamped on your passport. Alternatively, if you have the combo card with you, you could come back on the combo card on advanced parole, which will have a secondary inspection, because now you are paroled into the country on the status of pending I-485 state. So remember, if you are traveling, you could either come back with a valid non-immigrant visa stamp or with the combo card, and your status in the United States after coming back will depend on which visa you use. Now how long can you stay outside? Now it depends on you. I wouldn't recommend you to stay very long. Few weeks is fine, but if you are going to stay for 6 months or a year, that could become a problem, because that could hinder your chances of approval for your I-485. You should consult your own situation with your immigration attorney before traveling. So those were some of the questions that came in, and I just wanted to answer them. So if you got value out of this video, please hit the like button and consider subscribing to my channel, and I will see you in the next one.